Welcome everybody to another installment of our distance learning series. We, just like you, are digesting, evaluating, and adapting to the constant flow of information and changes to our daily routines. To ensure that we're meeting all of your needs as small business owners across the state, we're putting out a whole lot of information on a lot of different platforms. So please make sure that you're checking in wherever possible and whenever possible. Our website is updated daily, sometimes multiple times a day, featuring links to our COVID-19 resource page, along with a full list of upcoming classes, webinars like this one, and other events hosted by the Iowa Center and Women's Business Center. We have an Instagram handle at the Iowa Center, which is posting several times a day information about our upcoming events and local small business profiles, etc. Our team also created a Facebook group called Iowa Small Business Resources and Support. And that has been a really great place for members of the small business community across the state to ask questions, brainstorm, generally interact with each other, maybe vent a little, and learn about how we can help each other through the challenges that we're all seeing every day. In case you're unfamiliar with Zoom, we are recording all of these webinars to share on our website for anyone who needs to listen, wants to listen again, or was not able to join us in person. And all participants are muted. So if you have any questions, please use the chat function or the Q&A function at the bottom of your screen. As I said earlier, we're all learning to adapt and exist at distance. And one of the ways many small business owners can do that today is to maintain communication with your landlord, understand the language in your lease agreement, and if necessary, try to figure out a short-term solution that benefits both parties in that contract. So without any more from me, I'm going to turn it over to our presenters today. Bill Wright, Senior Vice President and Managing Director at CBRE Hubbell, and Samantha Wagner, who's an attorney with Iowa Legal Aid. Here are Bill and Sam to talk about tips for your commercial lease during COVID-19.
Well, good morning, everyone. Thanks so much for being here. We've got a real treat for our presentation today. We're here with Bill Wright, who has tons of experience working with commercial leases and the landlord side of things, the tenant side of things. And I'm excited to co-present and also probably learn a little bit too. These are weird times and we want to be available to you in any way we can that is helpful. I want you to feel empowered to stop and ask questions, or if you need more clarification or if something doesn't make sense, let us know. We want this is only as helpful as you understand it, so let us know. As Zach said, I'm Samantha Wagner. I'm an attorney at Iowa Legal Aid. I've been at Iowa Legal Aid for about 2 years. Prior to that, I worked in Texas doing a couple of different types of law. My experience at Iowa Legal Aid has been run the gamut of different types of legal services or legal inquiries, I suppose, but most of my litigation has been focused on commercial leases that go bad. So unfortunately, that's the sort of side that I've experienced, and I'm thrilled to be able to speak with Bill, who has hopefully more positive experiences with commercial leases. Bill, do you want to introduce yourself?
Sure. It's a pleasure to be here. Samantha, thank you for the invitation. Zachary and Samantha, really appreciate it. I am, as Samantha indicated in your screen shows, I work at CBRE Hubbell Commercial in West Des Moines. I have been a commercial real estate broker for about 28 years and manage a staff of about 35 salespeople and about 40 total people here at CBRE Hubbell. My specialty is in the office and retail markets, both as on the tenant representation side and also as the landlord side. So my hope is what I can do for you today is provide a little bit of viewpoint from both sides, not only those of us that are tenants and are faced a situation like this with COVID-19 and the coronavirus, and how do we keep our cash flow? Our cash flow is not where it was due to decreased revenue. How can we work something out with the landlord? And then I hope to be able to also provide some insight on things that the landlord might be looking at and some of the important issues from a landlord's viewpoint. And you're gonna hear a lot of us, both Samantha and I, talk a lot today about communication, and that communication with your landlord is paramount in these types of situations. And hopefully we'll all learn a little bit together. So appreciate the opportunity to be here, Samantha.
Great. No, I'm excited to present with you, and I really do think I'm going to learn a few things. So that's awesome. Bill, I don't know if you wanted to talk a little bit about your involvement with the Iowa Center.
Absolutely. So I am a board member at the Iowa Center and have been for a couple of years now. I've actually really exciting part that's kind of appropriate for today's discussion is that that I have a 3-person sales team here at CBRE Hubbell that I lead on a personal basis, and we just got done negotiating a new lease for the Iowa Center in their new location. As some of you may or may not know, they moved from their former Clive location on University Boulevard to a new location on Grand Avenue, beautiful new offices. That unfortunately aren't being used right now with this pandemic, but it is, when all this passes, we hope that everyone that's on the call today will have an opportunity to see the new offices and see just a great new atmosphere, real close to the governor's mansion at Terrace Hill. And it's at I believe it's 2210 Grand Avenue. If Megan's on the phone, she can correct me if I'm wrong, but so yeah, I just have loved the opportunity to be on the board with the Iowa Center, and this is my first Zoom call like this webinar, so I'm just so grateful to be here today.
Awesome. Megan, the CEO at the Iowa Center, has chimed in to say that Bill and his people are the best team ever and did an extraordinary job for the Iowa Center. So I think we're in good hands today, everybody. And she confirmed that the address is 2210 Grand Avenue. I thankfully had a few opportunities to pop into the new location, and it really is beautiful. I love those rooms with the Iowa Center colors on it, and very collaborative space. That's very exciting as the Iowa Center starts a new chapter at a new place, right?
Absolutely, we're real proud of that space. Unfortunately, it's not, as we said, it hasn't been used much the past month, and may not be used much here in the next 30 days, but we'll get back in there. I'm positive of that. So.
Something to look forward to, right?
Absolutely.
All right, so let's see if my slides will move forward. Oh. We will have a huge ribbon cutting when we get back to normal. Yes, excellent. I can't wait. I will be there with bells on. So in case you've never heard of Iowa Legal Aid, I just want to go really briefly over some of our services. So my position is I represent small businesses and nonprofit organizations, and I really do anything in the lifespan of the business, from startup to shut down, everything in between. Litigation, transactional legal services, drafting, random questions. Hey, can I do this? Or what happens if I do that? We really provide the free legal services that run the gamut. I wanted to let you know about a few resources that are available to everybody, regardless of income. One of the issues with Iowa Legal Aid is that we represent low-income business owners, so you have to be around 200% of the poverty line. Though, of course, if you are close, please contact us, and we do have an ability to make some exceptions from time to time. So one of the resources I wanted to let people know about is our coronavirus outbreak page on Iowa Legal Aid's website. Our litigation director has been working around the clock. I really think he doesn't sleep because he's always updating the website with the newest information that's available. So really practical questions that folks are having right now. You know, what happens if I can't pay my residential lease, right? Or am I eligible for unemployment? Or I think I might have a consumer fraud issue. We're addressing all of that on our website, so you should definitely check it out. Additionally, Iowa Legal Aid, in partnership with the Iowa Bar Association and the Polk County Bar Association, has started a free legal advice hotline related to COVID-19. You do not have to be eligible for Iowa legal aid services to call into this hotline. What will happen is you will be screened to see if you are eligible, and then legal aid will help you. Otherwise, you'll be passed along to the ISBA, where volunteer attorneys have graciously agreed to give people key legal information and advice that they need right now. We're dealing with any sort of legal problem related to COVID-19, eviction, unemployment benefits denial, identity theft, anything like that. Feel free to call in. I've got the number up there, but just so you know, it's not like our normal hotline. It's usually where you're going to leave a voicemail and someone will call you back. So you can expect that that's how that will be run. Otherwise, of course, here's my information for how to apply for our services at Legal Aid. The easiest way to contact me is to reach out via email. I've got my email up there. swagner@iowalaw.org is going to be the easiest way to get in touch. The last resource I would let you know about, so let's just say it's not a COVID-related problem or you're not eligible for legal aid. The Iowa State Bar Association's Find a Lawyer search is really, really useful to folks. If lawyers who participate in this will consult with you for $25 for the first 30 minutes, which if you are prepared and ready to have have your questions answered, this is a great resource and a way to get things done in a cost-efficient manner. So lawyers love a disclaimer, and I love a good disclaimer too. So we're not giving specific legal advice for your specific situation. I always tell people that the facts change the answer. There can often be more than one right answer. So just so you know, this is not tailored advice for you. This is just basic information. I don't know, Bill, if you have anything that you have to say for your people.
I do not. I'm
Okay.
I'm not an attorney, but we're going to talk about a lot of legal matters today, and I think this disclaimer will cover it. Thank you.
So generally speaking, with all commercial lease matters, if you follow basic contract 101 principles, you're going to be in good shape. I always tell people not to leave your good, sound business judgment at the door just because you fall in love with a location, or you're just so excited to start a business that you're just you forget all the things that you learned about being cautious. Remember, you never have as much leverage as you do before you sign. And so getting everything in writing certainly rings true when you're initially signing a lease, or if you're negotiating for rent relief for COVID-19. One thing I will caution you about is, I guess now is the time to exercise extreme caution. I cannot emphasize this enough. I saw a listserv email on Friday, and I'm not going to say where I saw it, but with ideas for landlord side agreements and things to consider about putting in agreements if you're negotiating with tenants in the light of COVID-19, and I saw some pretty concerning provisions. So I beg of you to ask for help with this and to advocate for yourselves. I think it's pretty obvious how an attorney can help, but I was wondering if Bill could speak to what he can do for folks in these types of situations.
It's a great point. Whether we're dealing with a pandemic or whether we're just in the process of finding a space during a time when there's not a pandemic, documentation and understanding what you're signing is paramount to any type of transaction. There are landlords, there are real estate brokers, there are people out there that, when you find a space you like and you've agreed to terms, I highly recommend whenever you are finding a space that you go to a non-binding letter of intent type of situation where the basic terms and conditions of the proposed lease are outlined in front of you before you go to that final lease contract that's going to be signed and become the actual contract between the landlord and tenant. And it is so important to understand, this slide couldn't be stressed enough, to understand what you're signing. There are things that, even after I've been in the business for 28 years, there are things in every landlord's lease is different. And there are things in every lease that I go through that sometimes I look at and I go, okay, I have to read 3, 4, 5 times, and I've been doing it for 28 years. I can't imagine, if you're in the business of selling a restaurant, or you're in a business of selling goods, antiques, and getting ready to sign a lease, whatever the case might be. I can't, imagine that if this is not something you do every day, looking at a lease and not in the failure to understand it is by far the biggest mistake. And we're going to talk a lot today about getting assistance, getting help, and how this relates to the current pandemic and the situation is Samantha's point that your biggest leverage point right now, or prior to signing a lease, is before you signed it, because the landlord, their motivation is they want you to sign on the dotted line. They want you to become a tenant, because that'll at some point that's going to start a revenue stream, an income stream for them that adds value to their building. That's clearly what they want. They want you to be there, and they want you to stay there for a very, very long time. As it relates to COVID, right now, the leverage somewhat has shifted back to, yes, you're under a contract, but it shifted a little bit back to the tenant side, because right now the Governor Reynolds, and we're going to be real interested to hear. You're going to hear a word called force majeure that Samantha's going to talk a little bit about, and we'll both talk about. But right now, it's basically out of elements out of the tenant's control, the tenant has had to shut down. If you operate a gym, a salon, basically, full gamut of what I'd call non-essential businesses right now, you're probably closed down. And that means revenue's not coming in the door. And it is so important to start a communication line with your landlord from the very beginning to basically explain to them your current financial situation, where things are at. And it has created somewhat of a leverage point, because the landlords, if they don't work with you as a tenant right now during this pandemic, there's a good chance that and all we have to do is read the paper, there's a chance a lot of businesses are not going to reopen. And making sure that you communicate that, and the landlord understands the predicament that you're in, which are elements really outside your control. None of us here can control what's happened with this pandemic, or control with Governor Reynolds' decisions to shut down business, which are the right decisions, but very hard decisions. So I just would stress so much that this is a time for communication, and whatever deals are made, whether it's pre-pandemic or during COVID-19, whatever agreements are made with the landlord, we want to document those, and we want to make sure that they are fair agreements, that you're not being asked to do something that's outside of the norm. And I know there's not a lot of norm right now. I get normal is not prevalent right now, but hopefully today what I can help you understand is kind of what some other landlords are doing that is really what will define norm for me.
Absolutely. And I think that it really is in everyone's best interest to come to an agreement. But as we'll talk about, we cannot force people to be reasonable, right, Bill?
Yep, that's
right.
So
I think the best thing that we can do right now is empower you to make decisions that are best for your business without being steamrolled or bullied, or even just, even in good faith, signing something that you think you understand, but it really means or says something else. And so, something that I always highlight on this slide is to beware the template, or beware the boilerplate. This is the thing that we have everybody sign. This is what we always use. Well, okay, but is it specific for my situation? Maybe you agreed on some other little thing that the landlord was going to do or provide or fix before you moved in, and make sure, as Bill said, you're really getting all that in writing. Capture that in writing.
One of the biggest things we see in terms of leases, and I know this is probably a pre-COVID item, is landlord work, a definition of the construction, the improvements that the landlord's going to be doing. And in a lot of commercial leases, especially with what I'd call small businesses, a lot of times an architect has not been hired to do a full set of plans for a particular construction project. And Samantha, I'm sure you've seen this a million times too, is, it's a description. It's verbiage in the lease that describes what work the landlord is going to be doing. If the landlord tells you, I'm going to build a demising wall, or I'm going to build a wall or an office inside your space, and basically, they say they're going to build this, and you've been verbally told that there's going to be outlets and data drops for internet inside that space. And if the lease doesn't say that, the right thing for you to do as a tenant, for us to do, is to ask that the language be modified, that it says the office is going to be built with, 3 outlets or 2 outlets and a data drop, or whatever the case might be. Don't simply rely on verbal conversations. It's not a matter of distrust. What it's a matter of is someday you may sell your business, or someday the landlord may sell their real estate investment. And there may be new people, successors, that are party to this agreement, and they will not know what the intent was when the agreement was originally signed. So therefore, complete documentation is a must.
Absolutely. And I actually have cases like that right now, and I've had them in the past. And so this isn't just something we're telling you for fun. There are real ramifications here. Any other thoughts, Bill?
No, I think that covers it. Yep.
So here are some things that are that may be in your lease provisions, right, or in your lease right now, that you should be on the lookout for, something that could have ramifications for you right now. The biggest one is continuous operations provisions. So a lot of leases require that tenants be open a certain number of days, or that there's certain penalties for going dark or not being open. You can think about it, it kind of makes sense. If you're in a strip mall, you want to make sure that there's, lots of business activity coming around and there's customers and things like that. But if obviously the governor shut down your business, or you have, decided it's a business, you're in your best interest as a business decision to not be open, that's something that you definitely are going to want to communicate about with your landlord.
Absolutely, Samantha. This is a clause, Samantha and I spoke offline last week when we were preparing for this, and it's a clause that, as a tenant representative, a broker who's representing tenants, we really tried to see if we can get this removed. Samantha brought up the perfect scenario, which is landlords that own retail shopping centers often want to make sure that their retailers are open because other retailers depend on other retailers. It's everyone needs to be open and create a shopping experience for everyone. I get that, but continuous operation provisions, we try to get them negotiated out. For everyone on the call, our path forward on that is, what we tell people is, and when we go to landlords, we say, listen, if we're going to continue to pay rent, we would like the right to be able to shut down our store if we make it known that it's in the best interest of our personal business interest to not have that store operational, but we'll continue to pay our obligations to the landlord. So that's really our strategy there, is we try to prevent having continuous operation clauses. They're in there. They're especially prevalent in retail leases. But in regards to COVID-19, this clause is in a lot of leases. And even though it's one that I don't like, it is in a lot of leases, and especially retail leases, as I mentioned. So if your business has been shut down due to this pandemic, one of the first things you want to look at is this clause is this provision in my lease? If it is, this is a subject that we need to call our landlord immediately and say, kind of for obvious reasons, I'm not able to fulfill this continuous operation clause, and you want some kind of acknowledgement, letter agreement or something from the landlord that they're not going to default you under the terms of your lease. Because as we're going to talk about, default leads to a whole bunch of other issues.
Absolutely. And this might come into play even if you're just having different hours than you might normally have, right? If you're normally till 9, but now a lot of businesses are having sort of truncated hours. So Communication is key. If you take anything away from us today, let it be that. So real quickly, a few other things that you might have are a subrogation clause where that basically provides that the party that suffers a loss or damage from the other party waives its subrogation rights to recover and is going to rely only on its own insurance. That might be something that you've got. Vacancies or permitted use. So this is maybe a little bit down the line from where we are now, but if someone does close up shop, who controls what can go into that space, right? Can it be a competing business that competes with you? This is something that you want to know about right away, right? If you have a coffee shop or a hair salon, probably you don't want another coffee shop or hair salon coming in next door. And then the last thing to look for is exculpatory clauses, which protect the landlord from being liable for damages, and usually are enforceable in commercial leases. This is another one that we tell people to try to get removed, or at least carve out, gross negligence, willful misconduct, and defaults by landlord. Bill, any other thoughts?
No, you talked about some attorney stuff that you're definitely more qualified than I am on some of those things. But no, I would just add, when you look at leases in terms of a situation like this with COVID, what's important is we talked about continuous operation, that's what I worry about. Number two is if, as a result of the pandemic, if there are some essential services that the landlord was required to provide under the terms of the lease agreement. So they needed to provide this service in order for the lease to be, as a responsibility under the lease. And if they're, as a result of COVID-19, not able to provide that essential service, that would be definitely a discussion point to contact your landlord and say, okay, we need to work something out here because under the terms of the lease, you're required to provide this essential service and you're not able to do so any longer.
Right.
The one thing I'd like to hear from you, Samantha, too, is condemnation has gotten a lot of, and condemnation is pretty much in about every commercial lease you see, and it's gotten a lot of press in regards to property owners' rights and an increase in property owners' rights and how hard it is for municipalities or anyone to condemn commercial property. It's not as easy as it was, I think, 15, 20 years ago. Do you think condemnation, does any of that come into this COVID-19 pandemic? Do you think that's something we need to look at?
As far as like a force majeure clause or something like that?
Yep.
Yes, yep. I think this is the big question right now. I know force majeure is on everyone's mind. When my parents asked me about it, and I'm like, oh, that's a thing I learned about in law school, and our professors were all like, this is sort of, well, let me back up. A force majeure clause is what's sometimes referred to as the act of God clause. It's basically excusing performance or excusing your duties and obligations under the contract if something happens that isn't your fault. So an act of God, an act of war, a natural disaster destroys things, right? What it's basically saying, if this weird thing that probably isn't going to happen happens, then you don't have to perform. Well, guess what? We're in a weird situation where something that doesn't normally happen has happened. And a lot of folks are looking at their force majeure clauses to figure out, am I still obligated under my contract? And I think that generally speaking, yes, condemnation or act of government or something like that certainly could be something to consider in light of force majeure clauses. That said, courts usually interpret these pretty narrowly. So unless it's explicitly laid out in the force majeure clause, I don't know that you're going to have a lot of luck enforcing it. I was talking to another attorney the other day from a corporation here in Iowa, and she was saying that there's so much talk right now among lawyers that no one will ever forget to list pandemic in their list of force majeure activities ever again. And I think that's absolutely the case. But back to your question, Bill, I do think that government condemnation is something that we should be thinking about. Even if it's not covered, maybe as a bargaining point, right?
Absolutely.
Even if it's not, if you think it's a weak argument, it's an argument. So,
Well, and another one, you know, I've been spending a lot of time reading CBRE's kind of their notes on the pandemic. They come out often, and one that never crossed my mind was, would COVID-19 actually, could it be determined a physical damage to the real estate? And the the strategy, or what was being thought of here, is that if there was a known case of
mhm,
someone who had contracted the virus within the building, in which a multi-tenant building, whether it be a shopping center or an office building, industrial property, and that the area, that building had to be sanitized, cleaned, and basically shut down, would that under a lease constitute as damage? I thought, you know, initially when I first read it, I was like, oh, you know, no way. I mean, that's not what we mean when we talk about damage. But again, I think it's something that could be argued.
you know who really is thinking, the people who are really thinking about that are folks in the insurance industry.
Yep.
So this is sort of beyond the scope of this presentation, but a lot of people, at least when this outbreak first happened, were asking, is my business interruption insurance policy going to cover COVID-19? And the answer was, generally speaking, it's going to depend on your policy, of course, but a lot of these policies require some sort of physical damage. So one of the attorneys that I was consulting with about this said, you know, he certainly thinks that there is an argument to be made if you had to shut down and, you know, decontaminate the premises, or there was an outbreak and, you know, something happened where you couldn't have customers for a few days, that there's absolutely an argument to be made that there was some sort of physical impact.
Yep.
You know, he was kind of giving an example of, you know, a similar case where he's up in Madison, Wisconsin, which is where I went to law school. And they had this very weird power surge last summer. And the power surge made it so that people couldn't operate their business, and they were kind of thinking of that as a physical impact. So absolutely, I think there is room for creative lawyering and creative, you know, interpretations here.
Yep.
I'm curious to hear though how that will look though from you guys, if you'll have any success with that.
That seems like a reach to me. I mean, that's just me personally, but
Stay
we'll
tuned, right?
any case study on it.
So here's some other things just to be aware of, right? If something happens with the lease and they need to try to default you or take you to court or something, there may be a provision that allows them to collect attorney's fees. There are some genuine questions about what happens to fixtures that you installed when you move out. There's often something in a lease called a merger or an integration clause that my clients certainly fail to understand, which is something that says, this is our final agreement. No other agreements count except for this. Any prior negotiations don't matter. This is it. We're both agreeing that everything is in here. So that's why it's so important to get everything that you agreed on reflected in the final writing. And lastly, tenant improvements are, you know, generally are required to get landlord permission, but it may be worth it to negotiate a time period for the landlord to respond and try to make some cosmetic changes without landlord approval, especially if there's some, you know, weird provisions in there about signs. I'm seeing, you know, just generally speaking, signs like we're open or takeout only or different things like that. And so if there's some weird rules about signs, that may be something to look out for.
Good point.
So who should I consult with before I sign? Please, someone, I beg of you. An attorney or a real estate broker, I think, are going to be your best bet. You know, it's never bad to loop in your accountant, an insurance provider, a franchisor, if that's something that you are participating in, as well as impacted third parties or other tenants at the location. I'm a big proponent of talking with other folks at the location to get a sense of how things are going. Bill?
Yeah, I would agree. You know, often we get contacted as a commercial real estate broker, we get contacted by someone who has an idea. And sometimes the idea is already, you know, perhaps it is a franchise and they already have a franchisor. And they're looking for real estate. They're looking for space in an office building. They're looking for space in an industrial building. They're looking for space in a shopping center. And we, as the real estate broker, what we can do is we go out and we do, you know, tour packages, market studies. We try to understand where the best place for you to put that business is located. And an important part, which I don't think everyone always understands, is when you are a tenant, you're 95, 99% of the case, you're not paying for that real estate broker, because much like when you buy a house and you have someone representing you buying a house, real estate brokerage fees are paid by landlords. They're not paid by tenants. And the property's probably already listed with another broker, and those brokerage fees get split, usually right down the middle, 50-50, kind of similar to buying a house. And there's really no additional cost to you to engage a real estate broker. And so that's why we encourage that, is just, you know, you want to know where the best properties are located, where should I put my business, what's available. Now, in regards to COVID-19, you know, for a good real estate broker, and hopefully I'll put myself in that category, our job doesn't end just when that lease gets signed, because for a lot of my clients in a situation like this, we're actually doing some workout arrangements. And granted, there's no fees really in it for us, but it's what we do as part of our service to represent a tenant. Is, you know, I have people that I've represented in the past that say, well, okay, my business is going to be shut down for 1, 2, 3 months. Who knows how long it's going to be. And can you contact my landlord, who you negotiated the lease with originally, and can you try to negotiate some kind of workout arrangement for this pandemic, COVID-19 period. And after the screen or after the slide, we'll talk a little bit more about what I'm seeing out there in terms of some of the resolutions of that. Usually after we find a location, we submitted a letter of intent, then the legal process starts, and that's when we recommend every time that you should contact your attorney. And your attorney should be the person that reviews that legal document and basically compares the letter of intent, what was negotiated by your broker, to the actual legal document, and then is looking out for all those other clauses that Samantha spent a lot of time working, pointing to today, kind of those gotcha type clauses. So that's important. The accountant, the third thing on the list there, is so important, especially if you're buying an ongoing business. My team's had good fortune. We sold a couple of daycare properties, one in Grimes and one in Waukee last year. And the accountant was with us every step of the way to try to, because it was more than just a real estate sale. There was what we call an asset purchase agreement done with that too. And we're in the middle of selling a hardware store right now. So really important. Insurance, I can't stress enough. I recommend every time we're representing a tenant that when you see the insurance clause, and the insurance is in every single commercial lease, you take that insurance language, you cut and paste it right out of the lease document, and you send it to your insurance agent to make sure that they're okay with the terms of that. Franchisor, we kind of covered that one. A lot of times your franchisor, if you're a franchisee, your franchisor has what's usually called a necessary franchisor addendum, or some kind of lease addendum that they require being signed. It usually has to do with if you as a franchisee default in the lease, the franchisor is given notice so they can try to cure the defaults and not harm the brand. That's a very important document that's often in a lot of franchisee agreements. And then finally, those last two on there, other tenants at a location. If you're uncertain on a particular location, or maybe you want to do a little investigative reference check on your landlord, we highly recommend, go ahead and talk to other people in the center. What if Bill Wright's your landlord, what kind of guy is Bill? Does he live up to his word? Does he forget to turn on to do snow removal? What kind of things does he do that can drive you crazy? Important to do reference checks. And impacted third parties, I think that one came from Samantha. I think you're talking about guarantors there and what kind of impact they may have on the lease document itself.
Absolutely. So here are some things that you should try to include. Cure language, as long as you're showing an effort to try to cure, there shouldn't be a default. If you're relying on an anchor store, consider asking for the option to terminate if that store closes, or the ability to leave early if it's just not working out. I think Bill wanted to hit on that a little bit.
Yeah, so we, a lot of times, especially in the new business, a small business, I don't know the current stats, but we've all heard the stats that not all new businesses make it, right? There's a vast percentage of them that are unable to make it for a period of 2, 3, 5 years. Well, your standard lease in the marketplace is probably a 5 year is probably the average. We see a 3 or 5 year as the most common. Well, if you're required to sign a 5-year lease, and this is a new business, if you shut your business down in year 2, you still have 36 months, let's say, of lease obligation out there. That landlord may have made an investment into your space when you went in there, and they're going to want to still get paid. So what we do from a tenant rep standpoint is we try to negotiate some kind of win-win solution where you have the option to terminate. Let's say if it's a 5-year lease, after the 3rd lease year, you have an option to terminate. Maybe you have to give them a certain period of notice, and maybe you have to pay back to them an unamortized improvement allowance or capital expenditures, leasing commission, something that landlord spent to get you in that space, but gives you a little flexibility so you know that you have a business decision to make that at the effective date of that termination, let's say it's the end of 2nd or 3rd lease year, you can give that landlord notice. You can still get out. Yeah, it's going to cost you a little bit of fee, but it's far cheaper than paying rent on that location for the remaining 2 or 3 years.
Otherwise, you have to call me, and then we have to try to come up with some sort of strategy and some sort of leverage to try to get you out of this. And we really, at the end of the day, have to depend on the landlord, being reasonable and recognizing that litigation is expensive and they may not be able to get their money anyway. So it's so much easier if you already just have that right in your lease.
Absolutely. Flexibility is key.
So there's a lot of talk right now about different government stimulus packages and loans and grants available to cover your rent obligations. That is beyond the scope of what we're talking about today, but certainly is something that you should be looking into. And I think that the Iowa Center is going to do some programming on that or has some, so certainly look into that. But let's get into the real meat of why you're here today, right? Oh my gosh, we're in this crazy situation, this wild, unprecedented situation. I don't know that I can pay rent. I don't know how long I can keep the doors open. What the heck am I going to do? So let's talk about it. I think fear is a very powerful motivator, but something that we can do. I think understanding helps reduce fear and helps you make better and clearer decisions. So let's just go through it. Your lease may already allow for some instances of rent abatement or an ability to not pay rent. Though they are limited, there are some situations. And Bill, do you want to cover these?
Sure. We've covered several of these already. Interruption of essential services. That would be, let's say you're in an office building and the landlord has locked the office building, says no one can go in there. That would be a situation where the landlord is not provided access. I have actually not heard of this case where a building has been totally locked down. I've heard of buildings being locked down to visitors. Heck, I'm officing in a building that's been locked down to visitors, but
right,
we can still come here and operate. So, but that would be an example. If there's an essential service that is no longer being provided. Casualty damage to the building. We spent some time this morning talking about that. That if there is, something that's been deemed damage as a result of COVID-19 cannot be argued. I agree entirely with Samantha's PowerPoint here saying usually requires physical damage. That's kind of my first thought to my mind, but it's something that's going to be argued. Condemnation. Not all condemnation clauses, usually they're in probably every commercial lease, but they're not all constructed the same. Some are going to be a little bit more, could be more expansive, that where a government shutdown like we've had may be determined to be some type of condemnation, which kind of leads to force majeure, the next one. But it's unlikely that a condemnation is going to provide rent abatement right off the bat, but it's something that can be argued. Force majeure is really acts of God, which was Samantha said earlier. And that's really where where I see right now, a lot of my tenants are hanging their hat on. This is the clause. You want to see if you have it. It's not in all leases, but you want to see what this says and how this could impact your business. I would add, I think now's a good time, Samantha, if you're okay with it, is just talk about what I'm seeing out in the marketplace as far as what people are offering.
I'm going to skip ahead to that slide just so everybody can have the visual too.
Oh, okay, sorry, I'm probably going out of control
here.
Or out of order.
Going rogue.
Yeah, the key to this whole situation is to create win-win solutions with your landlord, and there are a variety of things that I've seen. Now, I've seen from one extreme to the other. On one extreme, I have one landlord client that I represent who is a very easy to get along with, good landlord. And in a lot of cases, what they're doing is they're coming to the tenant and saying, here's the deal. I'm going to give you April, May, and June rent for free. We're not going to charge you rent April, May, and June. Here's a letter, sign this. And all we're doing is we're adding 3 months, on the back end of your lease. So let's say your lease expired in November of 2022. They're adding December, January, February onto that lease term, and they're giving you free rent for 3 months. In my mind, that's about as good as I've seen as far as what landlords are doing. The first one on the list is applying security deposits to month of rent. I have a shopping center where a landlord's doing this. They're basically saying you don't have to come out of pocket in April, but go ahead and apply. We're going to apply your security deposit to the April rent. Another one is the second bullet point, short forbearance or flexibility for government stimulus dollars to come through. I think, if you're not, we had a slide on it, and but if you're not a small business and you're not exploring the PPP program, Paycheck Protection Program, I think is the acronym PPP. The government is providing a lot of stimulus money to small businesses to go out there and help keep your employees employed and pay for that. So what a lot of landlords are doing is a lot of landlords are coming in and saying, okay, you don't need to pay us the April rent. Go ahead and let's apply for the PPP program. We're just going to kind of have a wait and see attitude. And once that money comes in, you can pay us when that money comes in. Again, a really effective, good way for a landlord to act in these uncertain days. Another one, and this is more common, or there's something I want to say about when you tack on additional months of rent. So landlords are saying, okay, if you extend your lease now, I'll give you some rent abatement right now to deal with this situation. Just be careful. I just ask you on this that if you only had a year left on your lease and a landlord's saying, hey, I'll give you 3 months of free rent if you put 3 years on your lease, and you have a good business and you're basically extending it out, I'm good with that, the short extension. If you still have 7 years left on your lease and a landlord says, I'll give you 3 months of free rent if you add 5 more years on it, you're probably, I don't want to say it, but you might be taken advantage of. And don't just be smart about a short extension. Don't, if you're going to renew your lease anyway and the landlord's giving you some immediate rent relief, okay, that makes sense. But if you feel like, hey, my business still has, a lot of term left and the landlord's asking me to do a long-term extension, probably is not going to make a lot of sense. And that's what that fourth bullet point is. Just use caution. We have some landlords right now. I have some landlords that are saying basically a lot of them are taking on a month-by-month basis, and they're just trying to treat each month separately. I'm good with that too, because we just don't know what's going to happen. Another thing that I think everyone here needs to understand is that the landlords are still going to be exposed to some of their operating costs. They're still going to have to pay insurance. They're still going to have to pay their real estate taxes. They're still going to have to provide probably some essential services, common area utilities, management fees. It's not snowing right now, but they, if it was, they'd still have to do snow removal, things like that. So some landlords are coming to tenants and saying, okay, you don't have to pay me your base rent, but can you pay me the operating expense elements of your lease, and just at least pay that minimum amount to kind of get us through to a later date where you can start paying base rent. And if those kinds of agreements, to me, make a lot of sense, if you still have the cash flow in order to pay partial of your rent, the operating expense portion, that's something that makes a lot of sense to me.
We had a comment from Shane who said, we had some tenants prefer to amortize the deferred months over the next 12 months rather than add a term. And it's worked well depending on their cash flow model and tenant history. And I think absolutely, I've seen some of that too.
Great point.
We also have run into 2019 CAM reimbursements hitting at the same time. Based on the large snow removal invoices that occurred in early 2019, it's created a big cash flow variable for landlords. So it's been used in negotiations from the tenant's perspective.
Yep.
Okay. Cool. Well, thank you for those thoughts, Shane.
Yeah, good points.
I'm going to back up. And so these are some solutions that we're seeing, but there's some good leverage out there to get to these solutions. So let's talk about some of the bargaining chips that you can use. You want to talk about this?
Yeah, so reaching an agreement makes, communication is just key with any landlord, and you just don't, I spoke to a landlord last Friday, and this landlord probably has 200 what I'd call mom and pop small business leases in shopping centers throughout Des Moines. And they said they were frustrated because they've reached out to every one of their tenants, and some tenants just have not even returned calls, which in this world just is kind of amazing that you're not communicating with your landlord on these issues, but apparently it happens. So, and not all landlords are probably returning calls either. It probably goes both ways. But yeah, so, these are some things. I mean, lawsuits and lawyers, absolutely, they cost money, especially if there's other problems with the lease. I mean, certainly communication and having ongoing communication with the landlord is paramount, because knowing where the landlord stands, where you stand, and hopefully, coming to some type of an agreement on how to handle things during this pandemic. Public image during a crisis, I think pretty self-explanatory. There's not a lot that can be done when your business was shut down by order of the state of Iowa. So, there's not a lot of negotiation from a landlord standpoint. I mean, it's hard for them to argue that you can, unless you're a restaurant doing carryout or you have a drive-through window. I mean, if you're a gym operator, for example, there's nothing you can do right now in terms of, I think all the gyms are facing with, people are closing down memberships and things like that. And it's the situation that we live in right now. Also, Samantha, maybe you want to cover the next one about judgments and
sure.
Kind
so
of a legal one.
Certainly, we're kind of getting the cart in front of the horse here a little bit, but judgments or taking this to court and, forcing you to try to pay the rest of this agreement or whatever it is, you can go to court, you can get a judgment, you can get a judge to say, yeah, you're obligated to pay that money. But frankly, that's only a piece of paper if this person doesn't have any assets to collect. So for a lot of my clients, I often use that. It's like, look, this person has no money. And so certainly we're in a much better agreement to try to work something out. It's going to be much better for you to get $50 a month rather than spend all this money on an attorney, spend all this money going to court. And then even if, there were assets to collect, it costs money to try to garnish your accounts or execute against your assets. And then even if you do go to court and get a judgment, even if there are assets to collect, it's really important to know that the law protects certain assets and items from collection efforts. This is something that Iowa Legal Aid does a lot. Call an attorney if this is happening to you. So this is, of course, assuming personal liability and that you signed the lease in your personal capacity, which means that even if the business can't pay, you're agreeing to personally pay, which unfortunately is something that I see a lot, especially for new businesses. Some other, points of negotiation is that this is a national crisis. Statistics for businesses closing are grim. I think Bill and I were talking the other day about how there's going to be a glut of available real estate after this. And so people really are incentivized to keep you in place with some modifications. That is at least some money, even if it wasn't as good as, what it would have been. Finding another tenant is uncertain. It's a tenant's market as real estate becomes more available. Additionally, if you've had a long and positive relationship with your landlord, or getting somebody new in there is a gamble. If you've been responsible and you've been a good tenant, hopefully you can kind of cash in some of those chips for holding up your end of the bargain. Of course, more bailout money may become available depending on how long this crisis unfolds. You might get more money that's currently available through the Paycheck Protection Program or an EIDL loan. So there's a lot of incentive here for folks to reach an agreement. And we want to make sure that you know that, and you don't just feel like you have no leverage here. I mean, Bill, did you want to talk a little bit about some of those statistics that you guys are talking about in your network?
So, I mean, this is, grim is the right word, unfortunately, but they're saying that the National Restaurant Association came out and said that 20% of the restaurants are not going to reopen. And for every 30 days that goes on, they suggest that up to another 10% would not reopen. So can you imagine if the government if we're shut down bars and restaurants for, let's say, 90 days, we could be looking 30, 40, 50% of the restaurants not reopening. And that is an incredible amount. To your point, Samantha, it's going to dump an incredible amount of real estate onto the market. It would probably, my guess is, shut down a lot of new construction, because there's no reason to build a lot of new construction when there's so much available product already there. And it's going to probably lead to some depression in rents, in lease rates. So it's going to be interesting. Our business is right now at CBRE Hubbell is pretty much shut down just because people are waiting to see what happens. But when our business, the brokerage business, does well when markets go up or markets go down, and my guess is when we do get through this pandemic that we're going to be extremely busy. It's not always going to be a positive story for landlords, but we're going to be extremely busy with a lot of available space and showing a lot of available space.
There's probably that is to say, if they can keep you in there and renegotiate that lease a little bit or give you some flexibility, that's at least one space that's covered.
That's right.
So, they have cash flow and they've got a business to run too. So again, it's in everyone's interest to reach an agreement, but we cannot force people to be reasonable. And I am seeing a lot of that on my end. So let's talk really briefly about what happens if your landlord can't and won't negotiate and you can't afford to pay, right? So it's Iowa Legal Aid's position that commercial landlords have to follow the same due process provisions that residential landlords have, provide a notice and a hearing to evict commercial tenants. That said, many leases provide something called a contractual lien that gives the landlord the power to lock out the tenant for defaults, including non-payment of rent. Regardless of what Iowa Legal Aid says, it's happening and you need to be aware of it. Of course, I should back up and say that what could happen or what is going to happen is going to depend on what your lease says, first and foremost. This is all just conjectural until we actually look at the language of your lease and what it says. Your situation is going to be unique. It's going to depend on your terms. And as Bill has said over and over, communication with your landlord is key. Even if the rent is not going to show up that month, landlord would rather know that.
Yep.
And, every landlord is different, but I really don't think it's going to hurt to communicate in most cases. So again, here's some things that you should know about, right? Lockouts. Some leases allow for the landlord to change the locks, kick the tenant out for defaults. Some leases I have seen actually give the landlord the power to seize the items in the location and sell them to recoup the losses from not being paid. I was talking to another attorney the other day who was like, oh God, that never actually happens. That's just something that's in there. No, I have seen this, folks. This was an issue in a case that I had where the client really wanted to liquidate, really wanted to be done, sell all their inventory and allow the landlord to get paid from whatever they could sell, but they couldn't because the landlord had seized their items and locked them out. It got even more complicated when some of the items belonged to a third party. The tenant was essentially acting as a distributor for that third party. So really the items that were being seized weren't belonging to the tenant, and it was a mess. In another case, a landlord seized items that had a large personal value to the tenant, so items belonging to a deceased child. This is not something that you want to be surprised by. So I certainly encourage you to take a look at your lease and figure out if this is something that could happen. The law also provides a statutory right to do this under a landlord's lien in the statute, but this is going to require first going to court, so it's not so much of an emergency as contractual liens or self-help provisions in those liens. But something that Bill pointed out, and I think is true, is that often before any of this happens, there's going to be a default letter. There's no right to that. It's really going to depend on the language of your lease. But most landlords are going to communicate and say, we expected your rent and we haven't gotten it. You've got 15 days to cure. I don't know, Bill, if you had any other thoughts about that.
No, you covered it perfect. That was great.
So here's an example of what these might look like, though I've seen it with all sorts of different language. So here are some other things that could happen. Accelerated rent in lease termination. Some of these provisions in these leases provide that if there's a default, the landlord can accelerate the rent. So basically force you to pay all the rest of the rent provided for in the contract, and while simultaneously terminating your lease. And then of course, most people can't pay that. So then they bring it to court to try to enforce a lawsuit. And then there's a question of whether you're personally on the hook for that, depending on whether you've agreed to be personally liable. Now, Bill says that he has seen very few tenant defaults rise to a lawsuit.
Yes, it's expensive to fight that. I mean, it does happen, but a lot of times I find that landlords have a pretty good handle on who their tenant is and what their assets are. And a lot of them are reasonable and try to figure out a way to avoid a lawsuit and come to some type of an agreement. But it's, I'd rather have it covered, documented, and as much flexibility and protection if I was a tenant up front than try to worry about that, hope for goodwill later.
Absolutely. So one thing that Bill said, and I wanted to ask him to elaborate on, is that the failure to communicate and then, some transparency in terms of the financial viability of the business,
right,
or failure of that, I guess, would be a reason why a lawsuit would be filed. Can you expand a little bit on, to what extent in these cases are tenants, commercial tenants, sharing the sort of profitability or the financials of the business with their landlord? Is that common?
Yeah, it's not common, but it does happen. And a lot of times it happens. I mean, there are occasions where an actual lease document, a tenant might have to share sales numbers with a landlord, so the landlord has some kind of clue on
per the terms of the lease, right?
Yep.
Okay.
might have some kind of clue on how the business is performing. But I find in situations where you know, a tenant's having trouble, they're having trouble meeting the lease obligations, the terms of the lease. I find that, you know, what I usually try to recommend to a tenant is, I'm like, okay, let's be transparent. Let's go into the landlord. Let's, you know, I'm not just telling them to show it, you know, your tax return, but to try to maybe show them a tax return, but show them, you know, how the business, the profitability of that location, of how the business is doing, and why the business is suffering. And if you're going to ask the landlord for help, having that information, that data behind you is always a much more effective argument than just going in there and saying, you know, if you don't help me, I'm going to have to close. If they have some kind of understanding of what the cash flow is for the business and why you're requesting this, and, you know, if they see that you're not taking anything out of the business or you're barely taking anything out of the business, that's always a much more effective tool to argue, Samantha.
Absolutely. Or for, you know, for your clients who had a daycare, right?
Yep.
Yeah, maybe it's struggling right now, but look, we've got 20 more kids signed up who are starting June 1st.
Yep.
We've got, you know, different things like that might be a way to leverage some of that information that you should already have, hopefully.
That's right.
So here's the thing, lawsuits are scary. I get it. Those cases where folks come to me that just have the most awful stomach ache because things are stressful are when these go to a lawsuit. But I want to let you know that even if it does go to a lawsuit, that does not mean that you're automatically going to lose. You do have some defenses. The first one is that I think the landlord has a duty to mitigate damages, right? They need to find another tenant to take over. Now, this is a pretty low standard, right? They just need to advertise it or do some, you know, take some reasonable efforts. And as we've talked about, now is maybe not the best time to find someone else to take over that lease. You know, if there were problems with the lease that existed prior to this lawsuit, that could be something that could be helpful to you. We argued diminution of value of the lease premises once when there was a big crack the landlord wouldn't fix in the floor, for example. If you've signed the lease as the business and not in your personal capacity, that may be something that brings you some comfort too. They can sue the business, they cannot sue you. And then, you know, especially in these times, these questions about force majeure, impossibility, unconscionability are all, these sort of common law defenses are all going to be something that comes up and is something to think about. So a little bit of creative lawyering and you know, creative lease negotiations, regardless of whether it's a great argument or not, it's something to raise, and it might be something that brings that landlord to the table, especially given how ridiculously expensive litigation can be. So we talked about bargaining chips. A little bit about do's and don'ts of negotiating with your landlord.
Yeah, you know, here's some items that I think are just great for your reference, everyone on the call, their reference. Dues, representation, we talked about it, get an attorney or broker. Please, if you don't understand a clause, please ask. If you don't understand indemnification or subrogation or some kind of clause, just please find someone who would understand it and ask about it.
We beg of you. We beg of you.
Exactly. Remember, this is a business decision. I sound like when I was shopping homes with my wife, trying to remove the emotion from it. You know, this is really, I mean, if this location doesn't work out because the landlord's not being reasonable with you, please understand that you could probably take your business and hopefully be just as successful somewhere else. So just try to remove the emotion is one of my recommendations. Focus on flexibility for your business. We talked about certain items like an option to terminate, an option to renew. Those are things. If you're taking something as a tenant as is with no landlord remodeling, you're probably going to have a lot more flexibility. Once the landlord starts to spend capital dollars on your space, your flexibility starts getting diminished. And if you have concerns about a landlord or relocation, we talked about this earlier, ask other tenants, get references. On the don't side of the column, don't sign a lease without reviewing it. Please do not rely on good faith or memory. Get it in writing. I would never allow your broker attorney to tell you not to worry about it as a clause. If you don't understand it, say, you know, spend the extra 15 minutes fee with your attorney or something and ask and have them explain it to you. I would really recommend, unless you are just absolutely confident in your business plan, signing a long-term lease without an out clause. You know, if the landlord wants you to sign a 10, 15, 20-year lease, just make sure that you know that business is going to be there for that long, because if it's not, you might want to have some type of out clause. And then our final number five, don't is just don't. We've talked so much about this today, but don't fail to communicate with your landlord.
Absolutely. So, you know, we talked about some win-win solutions that are out there. Let's say you get a solution and you've got an agreement. Awesome. It doesn't have to be complicated. Writing a quick little forbearance agreement or a little addendum to your lease doesn't have to be complicated. Here are some tips. Commit it to writing. Don't rely on good faith. Do consider things like due date and the ability to prepay, for example. So, you know, maybe you're amortizing it over a 12-month period, for example. Maybe you want the ability to, if you have a really great month, just pay that whole thing off. That make sure you've got that covered. Do state that you're not waiving any rights or remedies you'd otherwise have under the lease. This is a very narrow little carve out. And do put in a provision that allows the agreement to be signed in separate parts and electronically, right? Social distancing lawyering, right? Make sure you can sign it over the computer.
I like that.
So,
that's a good one.
we've taken a little bit more of your time, but I think all for good stuff here. We do want to allow some time for questions or stories or jokes, maybe, if you've got something you want to enlighten us about. Bill, did you have anything else that you wanted to add while we've got this captive audience?
Yeah, I'm ready for questions. I know we went a little bit over, but it was a lot of great information. Thank you for running the PowerPoint. And hopefully there might be a few questions here.
Yeah, it was fun. Questions from our friends? Well, you know, certainly we'll stick around for a few minutes to see if there's any questions, but I want to thank everybody for sticking with us and letting us go a little bit long. I think that the Iowa Center is doing tremendous work right now trying to be a resource to you. Legal Aid wants to be a resource too. There's a lot of folks out there who are pulling for small businesses right now. If there's some sort of programming that you want to see, or if there's a question we didn't get to today, I'm certainly open. Bill, I'm sure you are more than willing to share some thoughts on that.
I was wondering, you had your contact information in there, maybe on the chat room. I'll just quickly, if anyone's interested, I'll put my phone number and email in there.
Absolutely. Let's get that pulled up here.
While you're doing that, I'm just going to jump in for a moment, if you don't mind.
Sure.
I want to remind everybody about all of our COVID resources. The front page of our website has links to our main and sub COVID-19 resource pages. We have a link directly to scheduling one-on-one coaching. If you would like that, our whole team is here to offer our knowledge and support however we can for anyone who calls in. We have a lot more webinars coming up just like this. We have some regularly scheduled programming. Tomorrow, Topical Tuesday, is on crafting an elevator pitch. We are creating some more education opportunities that are a little more tailored to the current unique situation that we all find ourselves in. And so please continue to stay tuned to our website and our social media, our Instagram and our Facebook, and definitely take advantage of all of those opportunities that we have coming up. I absolutely want to thank Sam and Bill again. We put out a request to all of our board members and all of our friends, industry experts, if they would be willing to come speak on any of these webinars. We have so many topics that we want to cover and have covered. And Bill was one of the very first to hop on the opportunity. So thank you so much, Bill.
Absolutely.
thanks to Sam, this is her 4th one that she's done. I know that Iowa Legal Aid is absolutely swamped at the moment, and we feel so thrilled and blessed that she continues to give her time and knowledge to us during these webinars.
Looks like we have a first Q&A come in from Gail.
Yep.
All right, what is the name of the office that offers 30-minute sessions? Okay, that's the Iowa Find a Lawyer website. And I'm not sure if, Zach, if y'all have linked to that, but I can send you that information.
Yep. We have a link to that on our COVID resources page, and I will copy and paste a link to that in the chat here.
Awesome. I like working on these cases. I think this is one of the places where we can be especially helpful to clients and folks who are in crisis. So if you or someone in your network is having trouble with their landlord right now, tell them to contact Legal Aid. We think that this is some work that we can be helpful at with people. You know, maybe we'll have to call on Bill to get his perspective on things too, now that we know each other, right?
That's right. That's right. Happy to do so.
All right. Well, everyone take good care of yourselves. Wash your hands. And I don't see the broker contact info. Fernando says, okay. It's right here in this chat box, Bill Wright. His number is 515-210-3050, and then bill.wright, WRIGHT, at CBRE-HUBBELL.com. All right, everybody. Thank you so much. What a pleasure.
Thanks, everybody. Hope to see you at the next one.